So thank you for everybody to come to the privacy talk. I'm be honored to be invited to Sayid from Abu Dhabi. This is a very exciting topic to talk with him this moment. So thank you for Sayid to come to the privacy talk.
Thank you, Koi-san, for this kind invitation. And it's a privilege actually to be a part of Privacy Talk and to be with you today from Abu Dhabi.
Thank you. First of all, I'd like to share his profile. Sayid is the head of operations at the Office of Data Protection Commissioner, Abu Dhabi Global Market, ADGM, with over 10 years of experience in data protection and privacy. He's responsible for overseeing the operations of the office. Prior to moving to the UAE, Sayid was a lead enforcement office at the UK Information Commissioner's Office. He has also held positions at various UK government departments as data protection, compliance, and professional. Sayid has an LLM in information rights law from Northumbria University and IAPP Fellow of Information Privacy. So it's a great to be honored having a talk this time.
Thank you, Koi-san.
Thank you. So let's move on to today's agenda. I'd like to ask you about your activity first. So you have a various experience so far at the data protection field. So could you tell us why did you start to work in the data privacy field?
Yes, absolutely. I mean, like many in the field, I can actually say that I fell into data protection and privacy. It wasn't something that I planned really. And when I finished university in Southampton, I moved up to an area called Stockport, which is in the northwest of England. So I moved from the furthest south to the northwest. And that's where I started actually my first role in the civil service. I worked for a non-commissioned government body called the Child Maintenance and Enforcement Commission. I worked as an enforcement officer for the non-compliance team of CMEC, which was called at the time, and my role predominantly focused on safeguarding the rights of children, and in particular ensuring that the non-resident parties or parents in this case can contribute to the upbringing of this child. So therefore, I'd spend a lot of time working on casework, dealing with these type of issues, and transparency played a key role in that. It's a common understanding when you join the UK public sector and you work in the UK, any UK public sector organization, that you have to be transparent in the decisions, the information that you do, and decisions that can be taken by yourself as a case officer. And during training of that, you're always emphasize that information that you work with can be published online through freedom information requests. So you have to ensure that you write and you do your work with a level of integrity and transparency in your day-to-day operations. But what I learned over the years is, whilst it's called casework, it really is the processing of personal data. And it can, in some cases, have an adverse impact to individuals. So our actions as case officers, or inactions at times, resulted in direct impact to families and children. And our powers and decisions, even though they're given to us through law, that doesn't mean individuals don't have rights. And that's really when I had my first interaction with data protection privacy, through the use of individual rights. I received my first subject access request, I believe at the time, this was about 2 months into my role. So at that point, really, I had this level of curiosity. I was quite new in my job. I'm learning the ropes, and I get introduced into data protection and privacy. The rights, individual rights, and even though I did not have a good understanding of the law, the right to respect one's privacy. I recognized that it seemed like the right thing to do as a case officer. So as an individual, individuals should have a right over their personal data. They should have, the right to ask questions, request a copy of the file, and the data that you use are created using, and you're making decisions upon. So that's really how I fell into data protection and privacy.
Thank you. You had a great experience in United Kingdom through the data protection field. So could you tell us more about your work at the UK government, especially for Information Commissioner Office?
Good, yeah, thank you. I'm sure. So after my time at Child Maintenance and Enforcement Commission, CMEC, I moved within the UK Civil Service. So I worked for the Department for Work and Pensions at the time as a compliance officer. Um, and then I moved into what's known as the Her Majesty's Revenue and Customs, which is like the tax authority in the UK, both in Manchester. Um, and through that, I was working far more working with subject access requests and casework again, but far more interactions with individual rights and lawyers, third-party counsels who are defending their clients, whether it's a DWP case or in HMRC, it would be, casework around, tax and collection and use of data as well. But following a couple of years, I think working in the civil service, I found that by chance that there was a job opportunity at the Information Commission's office, and really it was my first interaction because I didn't know that the ICO was so close to Manchester. For those who are not aware, the Information Commission's office is actually located not far from an area called Stockport. It's in Wilmslow, which is about 10, 15 minutes drive from Stockport, where I lived at the time. So I noticed there was an opportunity there and I applied for it. And it was for an enforcement job working for the Information Commissioner, which I was successful for. I worked in what was known at the time as the Civil Investigations Team. So it was my job. I was responsible for conducting investigations into companies where there was a breach of the data protection law. But in particular, my focus area was what was known as the breaches of the seventh principle at the time. So that's the principle of security under the 1998 UK Data Protection Act. So that was, I had a sector speciality. I was focused on also certain key sectors. So my area was finance, local government and health. So I spent 3 years at the ICO really before I moved into a group data protection officer role in the UK for a large charity called Turning Point. And this was a charity that was focused in mental health and substance misuse. So it worked with a lot of sensitive data and it worked closely with local government authorities as well as other sectors. And it was my first real big exposure from a regulator back into a company side where I was responsible for setting up the data protection framework. And of course, following that post, then after a couple of years there, I was moved out here to Abu Dhabi, and so my journey in data protection really in the UK really projected me and catapulted me really to my position in Abu Dhabi in late 2018, where I was managing the global data protection program in Etihad Aviation Group. Etihad had been one of the largest Middle Eastern airlines, but I worked. My team and I, we worked. We were overseeing the global operations of Etihad. So we were operating in over 60 countries, 10 legal entities, and I was responsible for coordinating and managing and advising on data protection matters across the group. So across, all the different time zones from Japan, because we did fly to Tokyo in Japan, all the way to California, that side of the states. So, and then obviously that's what led me to my current role, where I moved back into Abu Dhabi Global Market.
Yeah, that's very cool. I think it's a very rare experience to have a various perspective to work on even the data protection in the middle of the creation. So I think that you are currently working at the ADGM. So what is your basic role? You probably sit in the head of the data protection at these organizations.
Yes, thank you. Look, I'm just going to share my screen at the moment. Give me a second. If you can give me control to share my screen, I will share. I've got a few slides where I can give you an overview about data protection here in ADGM. So ADGM is actually, it's a financial free zone jurisdiction in Abu Dhabi. It's a, one second, let me just, there we go.
Sure.
Just share. Perfect, thank you. There we go. So Abu Dhabi Global Market, so it's a financial free zone jurisdiction. And what that means, I think, to many of the listeners is it's a jurisdiction within Abu Dhabi. The best way I can describe it is like the Vatican in Rome. In ADGM, it was set up as a financial free zone jurisdiction. And a free zone means a establishment, a jurisdiction within the country. And here, the laws of Abu Dhabi and the UAE does not apply to ADGM. ADGM can set up its own civil and commercial laws, and it governs that through the use of its courts. But ADGM was established actually in through Cabinet Federal Decree number 15 of 2013, which established a financial free zone called Abu Dhabi Global Market. Abu Dhabi Global Market has a jurisdiction. It's the island of Al Maria. So there is an island in the center of Abu Dhabi where the jurisdiction, the whole island is regulated here by Abu Dhabi Global Market. And there's different authorities and courts that regulate here in ADGM. So as a highlight, so the key thing to understand is ADGM is a jurisdiction within Abu Dhabi, within the UAE, that is able to enact and regulate laws across the island in our jurisdiction. And the way it functions is ADGM has 3 independent key authorities, which are the Registration Authority, the Financial Services Regulatory Authority, and then you have the ADGM courts. And you have the board of directors here in ADGM, which act as the legislator for the island. They're responsible for passing legislation on the island. So I work for the Office of Data Protection. The Office of Data Protection, I report into the Commissioner of Data Protection, Mr. Sami Mohammed. We regulate both ADGM entities, but also the authorities here. And the different authorities, I will quickly just give you an overview, is the Registration Authority is responsible for licensing businesses to operate in ADGM. To date, there's around 4,500 businesses operating on the island within the jurisdiction of the ADGM. And we have the Financial Services Regulatory Authority, where it's responsible for regulating the financial industry and financial sector. So they govern all activities relating to financial activities on the island, whether that's banks or other financial institutions. And then you also have the ADGM courts, which is responsible for administering the laws and regulations on the island. So if there's any grievance disputes or anything, there's an independent court, which is headed up by Lord Justice Hope, and responsible for administration and determining civil and commercial disputes on the island. The Office of Data Protection is the statutory supervisory data protection authority here in ADGM. We are responsible for regulating all companies within our jurisdiction. And just a quick overview, just so you can see, we have some of the largest companies here in ADGM that call ADGM home, and we're responsible. We regulate them as the Commission's office, so we regulate the ADGM data protection regulations here on the island.
Thank you. Yeah, there is pretty advanced in finance field to organize the creation of the new structures of the data protection. We can learn from your quite honest activity. That is a very excellent. So I would like to move to the next questions. I think the ADGM it's a very attractive place for the financial sector at this moment. So could you tell us what did you do to enhance the awareness of data protection in ADGM at this moment?
Thank you, and that's a good question. So the Commissioner of Data Protection really is important. He has several statutory obligations, right, as part of his responsibility in the office. Raising awareness is one of them, and it actually forms a key one. Under our regulations, the Commissioner must, promote public awareness and understanding of the risks, the rules, and the safeguards when it comes to the rights of individuals, when it comes to, the processing and use of their data. But also, we have an obligation to also promote awareness to controllers and processors, telling them about their obligations under the law. So because whilst we have a statutory function and we can enforce the law, we need to be able to give organizations relevant information, awareness on what our position is as regulators, and provide them with the frameworks that they can use personal data in accordance with the law, in accordance with the ethical standards, but also ensuring that they respect the rights and freedoms of individuals. I would also highlight that when the law was enacted in February 2021, 14th February 2021, there was a 2-phase implementation period in our law. So we had the first phase, which was 6 months for brand new entities. So entities that were established on or after the 14th of February 2021 had 6 months to implement that. And for existing entities, so that was entities that were here, companies that were here on the island before the 14th of February 2021, there was a 12-month period so that they can update their frameworks. And through that period, we were active, emphasizing, compliance and awareness. In particular, we did a lot of outreach work where we did webinars, we did quite a few webinars, we did some conferences, we did some presentations with industry bodies. But we also, and you can see from our website, we issued quite a lot of guidance for companies, especially when it comes to leaflets, brochures. If you come to our offices, there's many brochures outside our office. So we we placed heavy emphasis on raising awareness, letting companies know this is our position when it comes to the collection and use of personal data, and this is our position when it comes to what we expect from you as companies, once they're using people's data as well.
Thank you. Yeah, the awareness is very important in our country as well, because a lot of companies now the figuring out what is the data protection and privacy. So we should promote in the concept and the principle to take the initiative to lead the data protection activity. That is a very significant and important role that you are taking at this moment. So the next question is also my curiosity is, probably you have experienced in the data protection in other countries, the jurisdictions. So I want to ask about is the difference of the data protection regulation in compared to the GDPR, the ADGM. So is there any difference in each different regulations?
Yeah, sure. I mean, let me just share my screen. I think it's probably better for me to just show you as well. So I think it's better for the audience as well. So once we enacted the data protection law, we did a benchmarking, right? So we understand that globally there are approximately around 140 jurisdictions with some form of data protection and privacy law. When we did our benchmarking for what laws should we look at, we looked across these laws, right? And we looked at which regulations had a robust regulatory framework. And the key thing, at least for businesses here in ADGM, but ADGM as a jurisdiction, is we wanted to look at consistency. What is the global high standard? And what do you think, what can we take from the best piece of legislation globally and apply it to our jurisdiction to at least give businesses that consistency? So we looked at actually GDPR played a key part of our assessment when we looked into that. In particular as well, because we are a common law jurisdiction here on the island, we looked at the UK's application of the GDPR, which is the UK GDPR, because as a common law jurisdiction, our courts, look at in Wales and other jurisdictions like that when it comes to interpreting the law. But also, we looked at the Council of Europe's Convention 108, which is the only international treaty that governs the processing of personal data. And here at the Office of Data Protection, we are an observer to Convention 108 plus, and they really set the standards when it comes to data protection and privacy laws. But in terms on your question, really, what are the key differences between us? What you'll find is actually there's a lot of similarities. When you look at, for example, the scope of the use of personal data, the scope of it, whilst the GDPR looks at, EU personal data, we also, take a similar approach. We're looking at personal data that is collected and used in the context of the activities of the establishment here in ADGM. So whilst there's many similarities there, we applied our law consistently to that it applies to any controller established on the island that is processing personal data, irrespective of where the processing undertaken. If it's in the context of the activities of the establishment here, it applies. In terms of the principles, there's a lot of consistency as well there. In particular, we set out the 7 principles for processing personal data, which includes, the accountability principle. That's similar in our law. We have the same principles, about fairness, lawfulness, necessity, proportionality, around, not using excessive data, the security, the principle for, retention, not keeping data longer than necessary. These are all consistent. Individuals' rights as well is consistent. We have the same rights when it comes to access, objection to the processing of personal data, when it comes to rectification, when it comes to portability, to be able to take your data with you. So there's still consistency in many of these areas. When it comes to individual rights request, there is a slight difference where we look at is 2 months with a possibility of extension for an additional month, while in the EU is 1 month with a possibility in certain circumstances to additional by another 2 months. But in total, 3 months it's consistent. We have the similar obligation when it comes to appointing a data protection officer, a lead supervisory authority. It doesn't really apply here because we are the authority responsible for ADGM as a jurisdiction. But we also we have independent supervisory authority, which is the Office of Data Protection and the Commissioner. Things such as data protection impact assessments. These are all within our law, as well as it's consistent with the GDPR. Breach notification timescales are all consistent. 72 hours. It's aligned to the GDPR standard. Data transfers in Chapter 5, which is also Chapter 5 in our legislation. It's consistent. Which allows the transfer of data when it comes to adequacy, standard contractual clauses, other mechanisms to send the data. We can rely on a derogation. This is all consistent. I think one of the key differences really is the enforcement powers. I mean, everyone's heard of the 20 million euros, 4% of global turnover fines. Here actually in ADGM, it's capped at 28 million US dollars, but that still makes us the highest fining regime and regulators office in the Middle East. We have the fining ability to fine up to 28 million, which makes us, one of the, we have the biggest stick, I'd say, in the region when it comes to enforcement of that.
Thank you. Yeah, that's very interesting. And also that you have posted on LinkedIn about the introduction of the ADGM. On your post, you mentioned that the ADGM courts directly applies the common law of the England and Wales. I'm a beginner of these regions. So could you tell us of this meeting? What did you want to mention about it?
Yeah, sure. So the court system here in ADGM is benchmarked to common law, right? So we have here in ADGM, we have the judge and are here all set up in accordance with common law practices. So in the ADGM courts, we have what's known as the application of the English law regulation of 2015, and what that law did here in ADGM is it applied English common law as it stands from time to time. It applies here in ADGM. So what that means is the judges here in ADGM will consider judgments in the UK and English common law when making decisions. So there are also 47 other laws of England and Wales that are directly applicable here, that it's been applied here. So what that does is it creates this level of consistency within ADGM when working with other jurisdictions like Singapore, Hong Kong, UK, and other common law jurisdictions. So when we say that the laws are directly applicable, that's what makes ADGM, I guess, unique in that, in terms of that it's not it's not a consolidated use of the law. The judges and the decisions here are closely aligned with UK common law practices. So what that means for data protection and privacy is that if there is an issue that has been decided upon in other common law jurisdictions, the courts here will take that into account, and will use that to then find what the meaning of the law truly means in these jurisdictions and apply that here. So that gives businesses consistency here, but it also gives individuals consistency when they are applying their rights here in Abu Dhabi in ADGM, that the same standards would be applied here as it would be in many jurisdictions that have a high data protection laws, practices and standards.
Thank you for your explanations. That is very helpful for the beginners to your original regions. That is very helpful to understanding of that. So the next question is about the new technology field. I think that Abu Dhabi is the one of the great positioning to embody the new technology over the world. So in the data protection field, it's in discussions how they can apply this new regulation into the new tech space, such as the blockchain, metaverse. There is a bunch of the technology that's coming right now. So in Abu Dhabi, so how do you work for the new technology and the data protection at this moment?
I think it's a really good question, because in ADGM, I think we're in a unique position that about 30% of ADGM companies and operating entities here are tech companies. So we make up a large amount of companies here that are focused solely on tech, fintech, regtech, and those sectors. And ADGM as a jurisdiction, I think it's the first in the world actually to introduce a comprehensive and bespoke regulatory framework for virtual assets activities, such as multilateral trading, brokers, custodians, asset managers, and we have a law that regulates that. We have a comprehensive laws that govern those areas. So, but in terms of our office and our office's role in this, as the Office of Data Protection, our mandate is to administer the data protection regulations. So we have an interest where there is processing of personal data, or there could be impact, to the rights of individuals. We recognize that blockchain technology has many benefits in many sectors, especially in finance. We're seeing some innovative ways that companies here in ADGM want to use blockchain to make finance easier, streamlined, probably more efficient, more transparent, right? The same in healthcare, and same where the use of data, especially diagnostics, they would use these technologies to help for help in that field. But of course, transparency plays a key role in that. And from our position, we would always focus on making sure that companies are aware that they have these obligations to individuals, that individuals are not surprised by the use of their data if data is used, and advise them of ways that they can use, enhance and use these technologies in a non-invasive way. So, for example, do you need to use personal data? Could you not use synthetic data, or data that might not necessarily identify a person? You could have identify, remove the identifiers from that. So these are many areas. But in terms of the metaverse, I've seen, especially as I have younger siblings as well, the direction of travel in this, and I can't help to look at things like Pokemon Go or Minecraft, or World of Warcraft, and these immersive games that really requires you to put a long part of your time, effort, resources, but also your information into these tools. And I think where the complexity will come into that is where you have one company, that's a large gaming company, it's easy to find who the controller of that information is, right? But then once you start creating this metaverse of multiple companies, hundreds, thousands of other companies that are all working within this space, who becomes the controller, who becomes a processor? These are issues that we'd have to, I guess, look more deep into across the board, not just here in ADGM, but regulators globally. We need to find convergence on this, because even where the data, where is the metaverse, would be even an important question in terms of when you're trying to find who has jurisdiction over this. So, but we always go back to safeguarding of rights of individuals and individuals, making companies be aware that individuals are the forefront of data protection laws. The reason we have these laws is about embedding the rights, making sure individuals are aware of how their data is used and giving them certain control over that information, right? But where I guess from a technology point of view and how we can support the sector and support these fields, is the law has many aspects where we can cooperate. A good sorry, are you cut out? Sorry, did you hear me? Okay, I'll continue. So in any case, what I was saying is, when it comes to data protection impact assessments, this is an area where we can cooperate. Let me just get, sorry, my video. There we go. So this gives us an opportunity actually, where if the activity in this tech sector can result in a high risk to individuals, we can get involved and consult with them, because in many laws, especially the GDPR and our laws as well, if there's a high risk to individuals, you have to do a data protection impact assessment. If the data protection impact assessment has risks that you cannot mitigate, then you have to notify us, and then we would actually work with you to try and address these gaps and mitigate these risks. Also, we will always look at, doing privacy by design, because this is an important aspect of any data protection law. Right? If you want to ensure that you have got it right from the beginning, then you should be thinking about embedding the principles around, the collecting of use purpose limitation within the initial beginning of the project, right? And then all the way up into the implementation, you should be considering individual rights. You should be considering security of that information. You need to ensure that there's appropriate technical organizational measures in place. You need to ensure that what does that mean in practice? Does that mean end-to-end encryption for transactions? Does that mean two-factor authentication? Mitigating, you need to mitigate identity theft. How would you do that in places like metaverse, blockchain, using the use of blockchain technologies? Reducing harms to individuals. How would you put away controls around that, where they're making staff aware of their policies of your organization, the procedures, how they can use data, how they shouldn't use data. Misinformation, which is a key area I think to many organizations, but also many governments. That the use and collection of use of this information can be used to have an adverse effect, not just individual people, but actual communities. You can result in ostracizing or in many cases, I don't want to name areas, but there's been many sensitive parts of the world. This could result in attacks on people as a result of the information. So we would always work with organizations where it comes to mitigating the risks, but the law also gives us power, so we will not be deterred to enforce, and we will use the stick where it's necessary and proportionate. Sorry, you're muted.
In terms of new tech field, I assume that there is need a collaboration, not just one single jurisdiction to work for the tech space regulations. So do you think there is many rooms to collaborate in other jurisdiction in between Abu Dhabi? For example, like in a crypto or finance space, there is some issues related to the money laundering or other legal check that is very significant for the against of the criminal actions. So probably there we have many controversial, especially for the data protections, to the investigated of the personal tracking of the financial transaction that is been against of the money laundering issue. So do you think it's any collaboration are you expecting to the other jurisdiction right now?
That's a really good question, and you raise a really good point, actually. So as a international financial center, we're part of many, as a jurisdiction, many treaties and many obligations at a jurisdiction level, but also at a country level when it comes to as a data protection as the Office of Data Protection, and the regulator for data protection on the island. We do work with, we're a member of what's the Global Privacy Assembly. That's the assembly consisting of all the commissioners globally. I think there's about 100, 100 members, or up to 100 members, I believe, globally, privacy commissioners, where we look at issues such as how do we share data when it comes to different areas. We're part of what's known as the International Enforcement Cooperation Group, where this data doesn't necessarily have to be personal data, but we can share information related to the breaches of the law, but also cooperating with other regulatory authorities. So through our partnerships, I think with many international forums, international groups, we'll utilize our ability. And also it's important to highlight that under our law and regulations, we're encouraged to work with others, in particular to ensure the rights and freedoms of individuals are irrespective of their jurisdiction. We have to, if a data subject here is impacted and we're investigating a company where they may have a group company somewhere else in the world, it could be in Japan, it could be in the US, it could be, we have to also be able to reach out to other authorities in these jurisdictions and cooperate. But you touched on a good point around when it comes to anti-money laundering and counter-terrorism financing, right? This is a big area for ADGM as a jurisdiction, as a financial center, and we have a financial intelligence unit, FIU here. We have that there are many occasions that they are able to work together and share information. And the key thing I'd emphasize, at least from a regulator's perspective, is that data protection laws should not be acting as a barrier, right? That they should be facilitating the flows of data. All it requires is to ensure that you consider the rights and individual rights and when it comes to rights of individuals, right? If there is a issue, or let's say an incident or crime that has been committed globally, the data protection law, it cannot be used as an excuse to withhold that information, because there would be a legal obligation to an authority or a company that they might have to provide that information, because the privacy, even though it's a key principle and key human right, it's not an absolute right. There are circumstances where your privacy can be infringed purely when it comes to, for example, the defense of when it comes to defense of a legal claim, to it comes to criminal activity, investigations, prosecutions, the use of the data in court processes, but also, to ensure the rights of freedoms of third people. They could be other people impacted by the processing of personal data, and they have a right to it as much as you have a right to it as a person. So yes, cooperation is a key part of our office. We would always be part of, these international bodies where we, facilitate the sharing of data, in particular, making sure that individual rights are safeguarded.
Yeah, absolutely. There is many opportunities to work in collaborations to make a safer financial ecosystem, to advance the finance of the business and field, as well as the other tech business, the tech environment that should be regulated for the safety reasons. We can go something to collaborate to enhance the fundamental rights, and as well as to sharing the great experience, great methods to prove that's in a more focusing on the customer safety, the customer experience. So that is the opportunity, the commitment for us. So thank you for your idea. So lastly, could you give us any message? You have many experiences so far in the data protection field, as well as that you are in charge of the very significant law to lead your jurisdiction. So could you give us any message for listeners?
Yeah, sure. I mean, that's a really hard question for me because, but I think what I'd tell your listeners is, data protection and privacy, it's an exciting area. It's ever changing and it's always evolving. The risks and challenges that I was managing, I guess, 10 years ago are different to today's risks for, when it comes to, the rights of as individuals, right? The new novel technologies and innovations, will continue to play a key role in our lives. I remember as a child, I did not have access to the level of information and technological advances that younger children have nowadays. If when it comes to phones, the use of devices. So, and through that, there will always be, considerations of risks when it comes to privacy, children's privacy, right? That's an important area, not just in the region but globally. How children's data is used. I think in the UK, and especially the ICO, they've launched a children's code, for example, to address that. When it comes to using and targeting children, and so I think what I would highlight to you and to all the listeners here is, if you are starting out in the field, whether you're new in the field or whether you really want to excel in this field, just always have this curiosity, right? Always try to learn more, try and understand. And, it's an area where you can be in the field for decades and you will still be learning because it's such a fast moving environment and fast moving place. So, but in my role as regulators, we will always work with companies, and I want you to give you that reassurance that as regulators, we're here to work with you. If we know what the risks are and you're able to bounce these ideas off us, we will work with you to try and mitigate those risks, because it's in our interest to try and find solutions or address, give you options that other companies can then, rely on, and then later on create this ecosystem where privacy rights are considered, through the beginning to the end. That's why privacy by design is a key part of our law, but most data protection laws, GDPR, etc. But we would always be pragmatic in how we interpret the law. We work collaboratively, and I think my view to you is don't feel free to reach out to your regulator or if you have any queries, because it's better for you to reach out to us at the start than later on, where there is a breach and then we're conducting an investigation, because at that point then obviously we would be looking at your processes, procedures, how you came to this decision, your rationale around it. But if you were able to consult us and work with us, then that would be favorable not just to us but to yourselves, but also to individuals.
Thank you for the great message. So we're gonna work on this field because it's very new, but it's pretty advanced in accordance with the tech evolves. So we should to collaborate it to work for the futures of the development of data protection. So Sayid, thank you for having the great time with you. It's a very honored to have a conversation this moment.
Thank you, Koisan. Thank you, listeners, and thank you everyone for joining.
Thank you.